Hello and welcome to the Minimum Competence episode for Monday, March 31st, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, a Supreme Court religious tax case blocked Trump orders on law firms, fired agency officials, and Apple fined over its ad tracking tool. Let's remember, the best way to predict your future is to create it. And read today's legal news. On this day in legal history, March 31st, 1933, President Franklin D. Roosevelt signed Senate Bill S-598, creating the Civilian Conservation Corps, or CCC, as part of his sweeping New Deal agenda. The CCC was a rapid response effort to the economic devastation of the Great Depression, designed to provide immediate employment to young, unemployed men. Within weeks of its creation, the program began enrolling thousands, ultimately putting over 3 million men to work during its 9-year run. The CCC operated under the Department of Labor, War Department, and Department of Agriculture, reflecting its blend of social welfare, environmental stewardship, and federal coordination. Workers were paid $30 per month, $25 of which was sent home to support their families, a vital lifeline during a time of widespread poverty. Projects included reforestation, flood control, soil erosion prevention, and the construction of trails and facilities in national and state parks. Legally, the CCC represented an expansion of federal authority into economic and environmental realms, and it raised constitutional questions about the scope of executive power during peacetime. While the Supreme Court would later strike down some New Deal programs, the CCC escaped judicial invalidation, in part due to its voluntary nature and its framing as a public works program rather than a federal jobs guarantee. The CCC's legal structure helped shape future federal employment and environmental programs, and it laid the groundwork for later conservation efforts like the Soil Conservation Service and aspects of the Environmental Protection Agency. March 31st, 1933 thus marks not just the birth of a New Deal agency, but a foundational moment in the legal history of federal labor and environmental law. The U.S. Supreme Court will hear arguments in a case brought by the Catholic Charities Bureau, a nonprofit linked to the Catholic Diocese of Superior, Wisconsin, seeking a religious exemption from the state's unemployment insurance tax. The group, along with 4 of its subsidiaries, argues that the state's denial of the exemption violates the First Amendment's protections for the religious freedom and church autonomy. Wisconsin law allows such exemptions only for organizations, quote, operated primarily for religious purposes, a standard the state Supreme Court ruled the charities failed to meet due to their primarily secular social service work. The Catholic Charities Bureau, founded in 1917, provides services like job placement and home visits for people with disabilities, but does not require employees or service recipients to be Catholic. After one of its affiliates was granted an exemption in a separate case, the Bureau and other affiliates sought similar treatment in 2016. The Wisconsin Supreme Court's 2024 decision upheld the tax requirement, stating the group's activities were charitable rather than religious. The case has broader implications for how courts distinguish between religious and secular work, with critics warning that a ruling in favor of the charities could allow large religiously affiliated organizations to bypass many government regulations, jeopardizing benefits for hundreds of thousands of workers. The decision is expected by the end of June, and the court is also set to hear a related case on April 30th concerning a proposed taxpayer-funded religious charter school in Oklahoma. 2 federal judges have temporarily blocked major parts of executive orders issued by President Donald Trump targeting law firms Jenner & Block and WilmerHale, which had been involved in legal efforts against his administration. The firm sued the Trump administration, arguing that the orders violated constitutional protections of free expression and due process. U.S. District Judge John Bates criticized Trump's order against Jenner & Block as reprehensible, especially for targeting the firm's pro bono work on behalf of immigrants and transgender individuals. He warned the order threatened the firm's existence by aiming to cancel its clients' federal contracts and restrict access to federal facilities and courts. In a separate ruling, Judge Richard Leon blocked similar provisions in the order against WilmerHale, calling it retaliatory and a threat to the public interest and justice system. However, he allowed a clause suspending the firm's security clearances to stand. Trump has signed orders targeting 5 law firms to date, and several, including Perkins Coie, have already challenged them in court with partial success. Meanwhile, law firms Skadden Arps and Paul Weiss folded like cheap suits and reached deals with the White House to avoid being targeted. Skadden agreed to provide $100 million in pro bono legal work and implement merit-based hiring, while Paul Weiss pledged $40 million towards mutually agreed causes. The executive orders mainly cited the firm's past involvement in investigations into Trump, especially the Mueller probe. Critics argue the orders are politically motivated attempts to punish opposition and intimidate legal advocates. 2 labor agency officials fired by President Donald Trump, Gwen Wilcox of the National Labor Relations Board and Kathy Harris of the Merit Systems Protection Board, will not be immediately reinstated following a decision by a divided panel of the U.S. Court of Appeals for the D.C. Circuit. The court declined to pause its earlier order that temporarily blocked lower court rulings which had reinstated the officials. Judges Karen Henderson and Justin Walker sided with the administration, while Judge Patricia Millett dissented. This legal battle tests the limits of presidential authority to remove officials from independent agencies despite statutory protections meant to insulate them from political pressure. While trial courts previously ruled the firings were unlawful, the appeals court has halted those decisions from taking effect for now. The panel's latest order did not include an explanation of its reasoning. Wilcox and Harris may still ask the full D.C. Circuit to reconsider the panel's ruling, but Sunday's denial of administrative stay could influence their next steps. Meanwhile, a broader decision on whether Congress can limit the president's power to fire certain agency officials is expected to be taken up in oral arguments scheduled for May 16th. The issue could eventually reach the U.S. Supreme Court, given its potential to reshape the balance of power between the executive branch and independent federal agencies. French antitrust regulators fined Apple 150 million euros, or about 162.4 million US dollars, for abusing its dominant market position through its App Tracking Transparency, or ATT tool, marking the first time any regulator has penalized the company over this feature. The ATT tool, introduced by Apple on iPhones and iPads, allows users to control which apps can track their activity. While Apple framed it as a privacy measure, digital advertisers and mobile gaming companies argued it made advertising more difficult and disproportionately impacted smaller publishers reliant on third-party data. The French Competition Authority found that while privacy protection is a legitimate goal, Apple's implementation of ATT was neither necessary nor proportionate and unfairly favored its own services. The decision followed companies from several advertising and media associations who hailed the ruling as a major win for their industries. Despite the fine, Apple is not currently required to change the tool's design. However, regulators emphasize that it is Apple's responsibility to ensure compliance going forward. Apple, expressing disappointment with the decision, noted that investigations into ATT are ongoing in other European countries, including Germany, Italy, Poland, and Romania. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and could leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, you can fool all the people some of the time and some of the people all of the time, but you cannot fool all the people all the time.